Hello and welcome to Narayana IS. I'm Pratik, your faculty for Indian Polity. Students, in the last part we started with the chapter Constitutional Design. In the first part of the constitutional design, we understood the basic concepts of constitution. What is constitution? Why do we need a constitution? Then we compared the South African constitution. We understood the importance of constitution, right? Then we also understood the how the Indian constitution was drafted by the Constituent Assembly. Then we understood key features of the Indian constitution, right? Then we understood why constitution is referred to as a living document, and then we also understood the political philosophies mentioned in the Indian constitution. But when we were discussing key features of the Indian constitution, I mentioned that one part of the key features, that is fundamental rights, will be dealt separately. And so in this lecture we'll be focusing on the fundamental rights mentioned in the Indian Constitution, the directive principles of state policy, and fundamental duties. Let's begin. So, rights in the Indian Constitution. Right now, we discuss the fact that the Constitution does more than just define the country's structure and which are the functions of the government. The Constitution, we discussed that it ensures that the government's power is limited, which means the government cannot take away the citizens' rights. Why? Because the rights given to the citizens, right? These rights, they protect the individuals from unfair government actions, which means it ensures that the democracy is functioning fairly and in a just manner. The Indian Constitution provides fundamental rights under Part 3 of the Indian Constitution. Which part? Part 3 of the Indian Constitution. Which means it guarantees what it guarantees is that freedom and protections. Right? Freedom of citizens and protection from the government. These fundamental rights are legally enforceable. Now, what do you understand by legally enforceable? Which means that if the fundamental rights are violated, the citizens can directly approach the Supreme Court and High Court. This is what we understand by the term legally enforceable. So we can either go to the directly to the Supreme Court, or we can also go to the High Court. Now, over time, in the last part, we discussed that the Supreme Court has expanded the meaning of fundamental rights. Right? For example, right to education was not mentioned in the fundamental rights. Now it's a part of fundamental rights, which means we see that the constitution, right, or the meaning of fundamental right was expanded, which means the fundamental rights were adapted, right, to the new changes, which changes, be it social changes, political changes, economic changes. So the courts ensured that the fundamental rights align with the changing situation on the ground. That's the reason the Supreme Court have decriminalized LGBTQ community. Right? Now let us try to understand the importance of rights. Right? Now let me give you two examples through which you'll understand the importance of rights. The first example pertains to right against exploitation. right against exploitation. Now, in the year 1982, during the Asian Games, the government had hired contractors, right? And these contractors had hired underpaid laborers, or they sort of did not pay the laborers the wage. And the contractors made the laborers work in poor conditions. So it is the government hired contractors who underpaid the laborers, and they made them work in very difficult or very poor conditions. Then a group of social scientists, they petitioned in the Supreme Court. They argued that the paying workers below the minimum wage was a form of begar, that is forced labor. This is what the social scientists had petitioned in the Supreme Court, which means this forced labor, begar, it violated the fundamental right against exploitation. We discussed in brief Article 23, which is fundamental right against exploitation, which means citizens cannot be exploited. The Supreme Court agreed to the petition of the social scientists and ordered the government to pay fair wages to the laborers. This decision of the Supreme Court reinforced the constitutional protection against exploitation. This is one example. Another example, which is pertaining to right to life and liberty. Now, there's a very famous example mentioned in the NCERT book. Machal Lalung from Assam, right? This athlete, his story highlights a violation of right to life and personal liberty. He was arrested when he was 23-year old for allegedly causing injuries and was declared mentally fit for trial. He was accused of causing injuries. Then he was sent to the mental hospital for treatment, but he was never tried in the court, which means he was accused of doing something wrong, but he was not tried in the court. Even after the doctors declared him fit for trial in the year 1967 and 96, no action was taken. The doctors declared him fit. He remained in custody for 54 years without trial. So when a person is accused, right, there's a trial. Trial in the sense, so there are two people. Let's say I am accused of robbery. So one person will try to prove that I have actually committed a mistake, committed a crime. The other person would try to defend me. This is referred to as trial. So this person was in jail without trial and was finally released in the year 2005 when he was 77 years old. Why? Because the National Human Rights Commission intervened. This case shows that how the denial of fair and speedy trial can violate the right to life and personal liberty. So in the first case, we discussed that the workers' rights were successfully defended by the court, and this led to justice. In the second case, the judiciary did not take any action. This led to violation of his right to life and liberty. So these two examples, right, it highlight the importance of enforcing or bringing into practice the constitutional rights, and how important is the role of judiciary in protecting the rights of the citizens. I hope Through these two examples, you understood the importance of rights. What is Bill of Rights? Now, the cases that we discussed, it shows that why rights are essential in a democracy. Rights must not only exist in constitution, but also it should be enforced to ensure justice, and most importantly, justice and equality. Now, in most democracies, the constitution mentions the rights of citizens explicitly in a clear manner, clear terms. This list is called Bill of Rights. When you explicitly mention, the rights, it ensures that the government cannot violate individual freedom, which means even if the government violates the rights, people have legal remedy, which means they can approach the judiciary. And restore their lost rights. I hope you understood what is Bill of Rights. So if I talk about the purpose of Bill of Rights, what is the purpose of Bill of Rights? What is the purpose? One, it limits the government power. It limits the, which means the government cannot take away the rights of the citizens. Second, it provides legal protection. It provides, which means if the rights are violated, the citizens whose rights are violated can approach the judiciary. They can approach the judiciary. So this is the purpose of Bill of Rights. Now see, the Constitution protects the Bill of Rights. The Constitution protects rights from two main threats. Protection of rights from two threats. The first threat from the private individuals or organizations. From the organization. Example, if someone faces discrimination at work, the government must step in to protect the rights of the people against whom the workplace discriminated. The second one is the government institutions. Which means the legislature, let's say the executive, the bureaucracy. So if they violate your rights, you can approach the judiciary. The Constitution ensures checks and balances to prevent the abuse of power. Right? And that's the reason the Bill of Rights. The Bill of Rights is a key part of democracy, which means it protects people from both the private as well as the government persecution, and most importantly, it ensures that the rights of people are protected, and thus justice. It ensures justice for all. I hope you understood what is Bill of Rights and the purpose of Bill of Rights. Now students will understand the fundamental rights in the Indian Constitution. Now, during the freedom struggle, right, the Indian leaders demanded individual rights, which means they asked or requested the British government to respect the individual rights. We discussed in 1928 the Motilal Nehru Committee. This committee called for a Bill of Rights, which means it stressed that the Indian people should have rights, that is legal protection for citizens. But when India became independent, there was no debate about including rights in the Indian Constitution. The framers clearly listed them as fundamental rights. What fundamental rights? A separate chapter was introduced in the Constitution with the name Fundamental Rights. So the question is, why the emphasis was given to the word fundamental over individual rights? Why fundamental? Why fundamental? Now, the term fundamental means that these rights are essential for the overall development of an individual. Without these rights, an individual cannot progress in his or her life. These are fundamental because this is the foundation, these rights are the foundation of democracy. So, be it development, intellectual development, moral development, spiritual development, economic development, without these rights, an individual may not make progress or take great strides in his life. So for the overall development of an individual, because when individuals grow, they progress, the country progresses. Simple. And that's the reason these rights are individual, these rights are important, so that enjoying these rights or utilizing these rights, an individual can unwind his potential and ensure that his life or his career progresses. The question is, how are the fundamental rights, how are the fundamental rights different from the ordinary rights? Fundamental rights and ordinary rights. What is the difference? Now see, fundamental rights, they are guaranteed by the constitution. One, they are guaranteed by the constitution. The constitution is mentioned that if the rights are violated, you can approach the judiciary. The ordinary rights, they are made by the laws in the parliament or in the legislature, which means it can be changed very easily, very easily. Now second, fundamental, if the government wants to amend the fundamental rights, then they need to amend the constitution, which means it requires special majority, two-third majority. But here, to amend the ordinary rights, you need simple majority, that is just 50 percentage, more than 50 percentage. Third, no government institution, no government institution can violate the fundamental rights. If they do, the courts can declare such actions unconstitutional. Here, government can easily, violate or sort of amend the ordinary rights. So, this is the difference between fundamental right and the ordinary right. Now, let us try to understand the role of judiciary in protecting fundamental rights. We already have discussed, right? The judiciary has a power and duty to protect the fundamental rights, which means if the rights are being violated, it can declare unconstitutional. But you need to remember that the fundamental rights are not absolute. They are not absolute. The government can impose reasonable restriction. For example, the freedom of speech and expression does not mean that I speak against the interests of a country. Or let's say I praise our enemy country vis-a-vis our country. I cannot do that. Freedom of speech and expression doesn't mean that I incite people against another group. No. Because here the government can impose reasonable restriction. What does it mean? It means that the government tries to balance the individual rights, my rights, and the rights of the society. Rights of the society. Now let us try to compare the fundamental rights of a country with that of South Africa. We know that South Africa, the way they adopted the constitution was after a lot of struggle. And when they adopted in the year 1996, especially 1996, especially after the end of apartheid. What is apartheid? Racial segregation on the basis of color. Now, the Bill of Rights in the South African Constitution is referred to as cornerstone of democracy. This bill explicitly bans discrimination, which means this bill, the Bill of Rights in the South African Constitution, it says that discrimination on the basis of religion, caste, race is strictly banned. It guarantees broad social, economic, and civil rights. Social, economic, and civil rights. Social, economic, and civil rights. Now, which are the key rights in the South African Bill of Rights? For example, we have right to dignity in South African Constitution, dignity. Then we have, let's say, privacy, dignity, privacy. Then right to healthy environment, right to healthy environment. Then other rights like, for example, right to health, right to food, right to water, social security, right to education, right to cultural, religious, and linguistic identity, right to information. These are the different rights mentioned in the South African Constitution. Now, to ensure that these rights are properly enforced, South Africa has a special constitutional court. South Africa has a special constitutional code to ensure that the rights mentioned in the constitution are implemented in letter and spirit. So then what is the difference between the rights in the Indian constitution and the comparison of the South African constitution with Indian constitution? Now we know that the Indian constitution, like the South African constitution, it guarantees a right to liberty, equality. But there's a key difference. And what is the key difference? In South Africa, right? In South Africa, the Bill of Rights includes socio-economic rights. Socio-economic, which are the socio-economic rights? Housing, healthcare, labor rights. But in our country, socio-economic rights, they are not mentioned in the constitution. They are made a part of the directive principles of state policy. In the last class, we discussed in brief what are directive principles of state policy, which means it guides the government to make laws, but they are not legally enforceable. So this is the main difference between the South African and the Indian constitution, right? And both the constitutions, right, they recognize that the rights must not be listed but also enforced. The main question or the main parameter is that the main parameter to see if the constitution is helping people is to understand whether they are implemented in letter and spirit. It ensures legal protection. It ensures legal protection and justice for all the citizens. So this is the difference between the Indian constitution and the South African constitution. Now students will understand each and every fundamental right of the Indian constitution one by one. We'll start with right to equality. Now, right to equality. Let's again try to understand the importance of this right through few examples. Now, first let's discuss discrimination on the basis of caste. Right? Let's say, for example, you are visiting a roadside, right? Let's say you're visiting a tea stall with your, let's say, with your friend belonging to the SC category. Now, the owner of the tea stall, he asked about your friend's caste. Before serving the tea, he asks the caste of your friend. Now, once you mention him the caste, what happens is you get a ceramic mug. You get the cup in the ceramic mug. But your friend is served in a earthen cup. Why? Because of his caste. Discrimination on the basis of caste. Let's say another example where a television channel removes 4 female newsreaders. Why? Over 45 years old, or like female employee of 45 years old, but allows male newsreaders of the same age to continue, which means when you cross 45 age, female newsreaders are not allowed, but the male readers are allowed. Now this is discrimination on the basis of gender. Discrimination on the basis of caste and gender. The first example was discrimination on the basis of caste, the other one is discrimination on the basis of gender. Now both the cases show clear discrimination, which means it is violating the fundamental right, because here people are not considered equal. People are not considered equal. Now, the first dimension that we'll discuss under right to equality is ensuring equal access and opportunities. Now, the right to equality, it aims to eliminate discrimination and ensure fair treatment. It guarantees equal access to public spaces or public places. And which are these? For example, shops, hotels, the entertainment centers, the wells, the bathing ghats, places of worship. Which means in these public places, no one can be denied access based on, let's say, religion, caste, color, sex, birthplace. This right also prohibits discrimination in public employment. Opportunities, let's say public employment, let's say the IS/IPS services example, which means it ensures that the government jobs are for everyone. Government jobs are for everyone. Now we know that Indian society historically has practiced exclusion on the basis of caste, which means people of certain categories were not allowed or they did not get access to education and government jobs. And one of the worst forms of inequality was untouchability. Worst example, worst form of inequality. Now, people were not even allowed to, visit places of worship, not allowed to use the same place as meant for other groups. And that's the reason the Constitution explicitly abolished untouchability in Article 17. It made a punishable offense. Also, the right to equality, it prevents the state from giving hereditary titles. Which titles? Like for example, Maharaja, Raja under Article 18. So, Article 17, Article 18, right? However, the military and academic honors are allowed, which means, let's say we have ranks in the military, right? Lieutenant, colonel, general, etc. etc. And academic honors, PhD, degree, doctorate. They are allowed. Why? Because they recognize excellence. They recognize excellence. So, by ensuring equal status and dignity for all citizens, this right to equality strengthens democracy, and it also promotes fairness and justice in the society. Now we'll understand equality in the preamble and the constitution. Preamble we discussed in the last class. It is the introduction to the Indian Constitution. Preamble, it upholds two key principles. Preamble, it upholds two key principles. The first one is equality of status. Equality of status, and the other one is equality of opportunity. Equality of opportunity. The first, equality of status, it ensures dignity and respect for all. Equality of opportunity, it guarantees fair chances for every citizen. But in a society like ours with deep rooted inequalities, simply granting legal rights is not enough, and that's the reason the Constitution empowers the government to take special measures to uplift. Uplift whom? The socially and educationally backward classes, the SCs, the STs, then we have women, we have children, right? Now, let's discuss about affirmative action, that is reservations. Now, many people who do not get the benefit of reservation, they argue that reservation contradicts equality. Reservation, reservation, it contradicts equality. However, Article 16, it states that the state may provide reservation in the government jobs for backward classes. The state has the power to provide reservation to the backward classes if they are not adequately represented, which means, let's say for example, the scheduled caste represent 20% of the Indian population. So in the government jobs at the different levels are 20% of the employees belonging to the SC category. In the educational institutions, of all the students and teachers working in the government or education institutions, does 20% of the total, let's say, a population in the educational institution belong to the SC? If they are not adequately represented, now the fact of the matter is, if the SC constitutes 20% of the Indian population, they are represented in, let's say, government jobs or let's say education institutions very minimally. That is, against 20% of their population, they are represented just 1 or 2 percentage. Thus, the right to equality is not just about treating everyone the same. No, it's not about treating everyone the same. It ensures that the those who are systematically excluded since thousands of years. They get this support so that they can come at par with others. So equality is not only about treating everyone the same. It is about what? It is about ensuring that people get support from the state so that they can come at par with people who are already socially and educationally well off. This is right to equality. I hope you understood the concept of right to equality, right? Now, students, let us understand the next right, that is right to freedom. Now, equality and freedom are essential for democracy. They cannot be separated. The first concept we understood of equality. Now, freedom or liberty means the freedom to think, express, and act. But this does not mean absolute freedom to do anything. Why? Because unrestricted freedom, right? Unrestricted freedom can violate the other's right and cause chaos. Freedom to think, express doesn't mean you have the right to hit others, right? Because that is, affecting the rights of other person. And therefore, freedoms are defined in a way that protects individual rights. And then here we are balancing individual rights and then interests of the society. How? By maintaining law and order. So, under right to freedom, we'll understand the concept of right to life and personal liberty, which is mentioned in Article 21 of the Indian Constitution. See, all these articles will be studying as part of advanced GS course, but the purpose is to understand the basic concepts. Now, the most fundamental freedom, the most important freedom is the right to life, the right to live, and personal liberty. And no person in our country can be deprived of life, which means a life cannot be taken away. It can be taken away except through a legal procedure. Let's say if you have committed a murder, then life can be taken away by announcing capital punishment. And personal liberty can also be taken away, but there is a due process, which means right to life and personal liberty, they are not absolute, they are not absolute, they are limited, they are restricted. Understood? Now, this essentially means that no one can be arrested without being informed of the reason. So, now when the police is arresting a person, right, his right is getting violated, but no one can be arrested without being informed. So whenever the police is arresting a person, the police has to inform him the reason, inform the person the reason why the police is arresting. Then the arrested person has a right to a lawyer of their choice, which means the police has to allow that person to hire a lawyer. Then as soon as the police arrests a person, right, the police have to present the arrested person before a magistrate within 24 hours. And then magistrate, who is independent of the police, not the district magistrate, no, the judicial magistrate, he decides whether the arrest is justified. So let's say, for example, the police will arrest me, the police will inform me the reason. I have the right to hire a lawyer. The police will present me before the judicial magistrate within 24 hours. Then the judicial magistrate will decide if the police can further detain me or order the police to release me. The Supreme Court has expanded this right to life over a period of time. For example, the Supreme Court has expanded this right to include other rights like right to live with dignity. So, right to life is not sufficient. Right to live with dignity. Then right to shelter and livelihood. All these rights were not part of the original constitution. These rights were expanded. So this right was expanded to include these rights. Right to, clean water, right to clean environment. So all these rights were expanded by the Supreme Court. Now we'll understand the concept of preventive detention. What is preventive detention? See, usually a person is arrested only when a person commits a crime. Only when a person is committing a crime. Now, in some cases, a person can be arrested or detained before committing a crime. Which means whenever the police has a suspicion that this person may commit a crime, the police detains the person. This is referred to as preventive detention. Preventive, why preventive? Because the police is preventing the person from committing a crime. If the police feels that this person is a threat to law and order, peace, national security. But this detention by the police cannot exceed 3 months. It cannot exceed 3 months. It can exceed, but there is a process again. Now, in many instances, yes, the police has misused this provision. The police have, detained many people without following the due process. And this actually raises a conflict clash between personal liberty and national security. So the governments, in the name of national security, under the guise of national security, have detained many people in order to curb their freedom of speech. I hope you understood the concept of preventive detention. Now, which are the other freedoms under the right to freedom? Which are the other freedoms? Now, it includes several other rights. But again, all the rights are subject to reasonable restrictions. They are subject to reasonable restriction. For example, if I talk about freedom of speech and expression. Now, this speech can be limited on the grounds of public order, morality, national security. So, if my speech and expression can cause public disorder, the police can, prevent a person from exercising his right. Freedom to assemble, which means I can, let's say, call people together to raise slogans, or let's say raise slogans against the government, to protest against the government policy. So these are the freedoms under right to freedom. Right. Now again, these restrictions can also be misused. Why? For example, in the name of, let's say, public order, the government can restrict a person from exercising his speech and expression. Now, during the Constituent Assembly debates, the Constituent Assembly that framed our constitution, some members worried that these restrictions could be used to suppress dissent like the British did. And this is what actually, the fears of the members of Constituent Assembly came true. Why? Because we have seen on many occasions, each and every government of all the political parties have, under the guise of national security, public order, morality, these are very subjective and relative terms. They have actually restricted a person's freedom of speech, expression, freedom to come together, assemble. Now, let us try to understand another concept, that is right of the accused. Who is an accused? For example, if a person is accusing me of murder, which does not mean that I am guilty, which means this person has accused me. He has a doubt that I have committed a crime. But who decides whether I have committed a crime? It is the judiciary. It is the judiciary. Which means even the people who are accused of crimes have rights. Accusing a person of doing some crime does not mean that he is guilty. Why? Because a person is declared guilty only when adjudged by the judiciary. Which means there's a maxim, judicial maxim saying A person is innocent until he is proven guilty. A person is innocent until he is proven guilty, which means everyone deserves a fair trial. I explained to you what is fair trial some time ago. The Constitution provides three protections to people who are accused of crimes. Three protections. Which are these protections? The first protection, no person can be punished for the crime more than once. Punishment. A person cannot be punished for the same offense more than once. Let's say a person has committed, let's say he has committed robbery. Now punishment is given of 3 years, 3 years jail. He cannot be punished again for the same punishment. Right? Then no law can punish an act committed before it was made illegal. I repeat, this is referred to as no retrospective punishment. Which means no law can punish a person or punish an act committed before it was made illegal. Let's say, for example, let me take an example of, let's say, eave teasing, or let's take a simple example. Let's say storing, or let's say stealing data of people, stealing personal data of people. Now let's say we are living, let's say, in 2000. Now in 2000, stealing personal data was not a crime, and a person has stolen data in the year 2000. But this stealing data was made a crime or punishment in the year 2005. So in 2005, this person who stole the data in 2000 cannot be punished. Why? Because in 2000 there was no such law. There was no such law. This is referred to as no retrospective punishment. Retrospective from a back date. And then third protection is no person can be forced to give evidence against himself. Let's say I have committed a robbery. No person can force me to give evidence against myself. I cannot force to give evidence against myself. I can give evidence to defend me, but no one can force me to give evidence against my interest. Which means all these three safeguards prevent wrongful conviction. What is conviction? When the judge declares a person guilty. This is referred to as conviction. When a judge declares a person has committed a wrong, declares that this person has committed a crime, this person is referred to as conviction or convicted. I hope you understood. I hope you understood right to freedom. Now let us understand another right, that is right against exploitation, which is Article 23 and 24 of the Indian Constitution. Now in India, millions of underprivileged people, they face economic and social weaknesses. It is very easy for a rich person to target a poor person, to exploit him. This is what the society, people across the world have been doing. Even you may have done it in your life. I'm pretty sure you may once or twice you may have done. You may have tried to exploit a person who is poor. And one of the worst forms of exploitation is begar. What is begar? It is forced labor. You are forcing a person without providing him, without paying him money. Now in the past, the landlords, money lenders, and people who are very, very wealthy, they force poor people to do work without paying them money. Without paying them money. This is forced labor or begar. Another serious issue is human trafficking, which means, what does it mean? Human trafficking, which means where people are bought, sold, and they are forced into slavery. And that's the reason the constitution has explicitly prohibited human trafficking or forced labor. It's a punishable offense. But unfortunately, even to this date, some form of forced labor is seen in our country, especially in the industries where the bricks are made. The constitution also bans child labor in hazardous factories, or industries, especially the children who are below 14 years. So with the child labor illegal and right to education now a fundamental right, right to education is a fundamental right. This right to exploitation, it provides legal protection to the most vulnerable people. It provides protection to the most vulnerable people. This is right against exploitation, which is Article 23 and 24. So right to equality, you know, equality, right to equality is 14 to 18. Freedom is 19 to 22. Right against exploitation is 23 and 24. Then freedom of religion is 25 to 28. Then cultural and educational rights for minorities 29 and 30. And then constitutional remedies, it is 32. Right? Though the articles will study more about or more in detail when we start Indian polity, advanced Indian polity. Now let us understand the right to freedom of religion. What do you mean by freedom of religion? Which means every individual has a right, has the freedom to follow his faith, to practice his faith, and also to propagate, spread his religion or her religion. And this again is a very, very important part of Indian democracy. Now, in the past, especially in the medieval era, the rulers were forcing people to convert. In the past, we have seen thousands of converts, thousands of conversion. Especially if the ruler is of a different faith, they used to force the people, subjects, to convert in their religion. And that's the reason, to prevent such instances in the future, the constitution has provided protection to people to follow their faith, to protect their religious freedom. Now, what do you understand by freedom of faith and worship? Every individual has a right to choose, practice, and spread his or her religion. It also includes freedom of conscience, which means I can choose, I may be born as a Hindu, but I have the freedom of conscience, so I can decide my religion. Even if I'm born as a, let's say, Muslim, Christian, Hindu, doesn't matter which religion I am born into, I can change my religion as per my conscience, as per my understanding of different religions. But again, this right to faith and worship is not absolute. What do you mean by not absolute? Which means the government can restrict religious practices. If the religious practices is, let's say, causing disturbance in the society, if it is immoral, if it is affecting the health, then the government can intervene and restrict it. For example, the practice such as sati, or the practice of human sacrifice, immolation. triple talaq, all these were part of the religious customs of different religions. The government banned it. The government says that sati, triple talaq is wrong, and so the government intervened and banned, which means again this freedom of faith and worship is not, not absolute. There are limitations. In the name of religion, you cannot do any immoral activities, immoral actions, no. But unfortunately, across the world, we see, in the name of religion, people are forced to do wrong things, especially in our neighboring country, Pakistan, Afghanistan. In the name of religion, they make a child wear a human bomb. This is so unfortunate. Now, at times, the regulation rules made by the government or actions taken by the government, they also lead to tensions between religious groups and authorities. For example, Rajiv Gandhi, he allowed the Ram Janmabhoomi gate. He ordered the authorities to open the gate. This caused a problem, confusion, tension between Hindus and Muslims. Another issue is with respect to right to propagate religion, right to, what do you mean by propagate religion? That is, you have the right to spread your religion, which means you can take your religion to people and practice the essential features of your faith. But propagate does not mean you force a person to convert into your religion. This is illegal. This is illegal. You cannot force a person. You cannot say that, okay, come, join my religion, be a part of my religion. I will give you 10,000 rupees. You cannot offer inducements to people to convert their religion. This again is illegal. Then, equality of all the religions. Now, we know that India is a home to so many religions, isn't it? The government, it is the duty of the government to treat all the religions, respectfully. The state that does not favor any particular religion, it is the duty of the state to remain neutral. India has no official religion, which means the public offices are open to, let's say, if you want to be a prime minister or president, any person belonging to any religion can become a president or prime minister, or let's say an IS officer. So, under right to equality, the government cannot discriminate anyone on the basis of religion, be it in the educational institutions or let's say in the government jobs. Now, the state run institutions, which means the institutions backed by the state. These institutions, educational institutions, they do not promote any religion. Or the institutions being supported by the state, they cannot promote any religion or give religious education, which means they are expected to uphold secularism. They are expected to uphold secularism, which means it ensures that all the religions are treated with equal respect and every citizen enjoys religious freedom. Every citizen enjoys religious freedom. This is what we understand by the term or concept of right to freedom of religion. Understood? Now, students, let us understand Article 29 and 30, which is the cultural and educational rights. Again, when it comes to culture, India is a land of different cultures, which means we have so many languages, we have so many traditions, we have so many religions. Now, there are societies where people have similar customs and beliefs, but India is a multicultural society, it's a plural country, which means it has multiple cultural groups which coexist, which means which live together. Now, in a society as diverse as our country, some some communities are numerically, in numbers they are smaller. They are numerically smaller, which means in numbers the numbers are small than the other religions. So the communities whose numbers are, let's say, comparatively small, should we force them to adopt the majority culture? So should we allow the Muslims, or should we force the Muslims, Christians, Sikhs, Parsis, Buddhists, Jains to adopt the Hindu culture? This was a fear in the minds of the Constituent Assembly members. That's the reason the Constitution firmly rejects this, and instead they recognize diversity as the strength of our country. Diversity as the strength of a country. And that's the reason, to protect the identity of each and every person and every cultural group, the Constitution guarantees the minorities the right to maintain and develop one's culture. The Constitution has provided this right. But the question is, who are the minorities in our country? Now, often it is understood that the minorities are defined only by religion. This is wrong. Minority is not only defined by religion, they also include linguistic and cultural groups, which means religion plus linguistic plus cultural groups. A minority is any group that shares a common language. Minority shares a common language, religion, or culture. But numerically, they are smaller. Number wise, they are smaller than the dominant group. It can be either in a specific region or the whole country. For example, let's say Hindi. People who speak Hindi are in minority in states like Kannada, Tamil Nadu, Telangana, Andhra Pradesh, Kerala, West Bengal. They are in minority. The Punjabis, the Sikh, are not in minority in Punjab, but they are in minority in, let's say, Maharashtra, which means these communities who are linguistically, culturally, religiously a minority, they have the right to preserve their language, traditions, and scripts. What? Language, traditions, and scripts. Now we'll understand the right to establish educational institutions. Education institutions. Now, to protect the identity of each and every individual, be it religious or linguistic, the Constitution has given the right to set up and manage one's own educational institution, which means the religious as well as linguistic groups can set up their own education institution. Why? To preserve the language, traditions, cultural practice. Also, educate the future generations about the heritage of their religion, or let's say language. Again, the government here cannot discriminate against any minority religion. The government cannot discriminate against any minority run institutions when they are providing aid or recognition, which means the government has to ensure that they are respecting and treating all the minority educational institutions in a similar manner. There should be no discrimination. I hope you understood this concept. So if an institution needs the required standards as set by the government, it is eligible for government assistance, which means the government also funds the minority educational institutions if they are meeting certain criteria. So it doesn't matter if the religious institution is managed by a minority or majority group. Even the majority group can maintain their educational institution. This is what you need to remember. For example, we have example like St. Xavier's, Aligarh Muslim University. So there are many such examples. Now, what is the significance of this right? Now, the significance of this right is that a country as diverse as a country. Now, you may not understand the importance of this right, especially in the context of which this right was incorporated when India got free. When India got free, there was a great level of illiteracy in our country. People were divided in the name of religion, caste. There was no unity. And then our country was a newly formed country. People were afraid, people had this fear whether the new government will establish or force the minorities to adopt the majority culture. In order, in order to get rid of these fears in the minds of minorities, in order for the minorities to feel safe and secure in our country, the constitution incorporated these provisions so that the minorities be least or rest assured that our rights, our language, our astha, language, script, culture, traditions, rituals are safeguarded in this country. And this is the reason why our country has remained successful in remaining united. Look at what happened with Pakistan. As they were not respecting the minorities, the country was broken up. The country broke up, and today we have a new country in the east of our country, that is Bangladesh. Bangladesh was former Pakistan, East Pakistan. In 71 it broke up. I hope you understood the cultural and education rights. Now students will understand the concept of another right, that is Article 32, which is right to constitutional remedies. Right to constitutional remedies, which essentially means that the Indian constitution ensures, all the rights provided in the Indian constitution, which means just mentioning the rights is not sufficient. You have to also enforce them, bring it into practice. And in case these rights are not practiced or brought into force, or if these rights are violated, equality, justice, freedom, religion, right against exploitation, if these rights are violated, then the citizens can approach the judiciary. And that's the reason this, which means this right, it guarantees all the rights mentioned in the Indian constitution. Dr. Ambedkar referred to this article as the heart and soul of the Indian constitution. What? This right is the heart and soul of the Indian constitution. Which means if the rights of an individual is violated, if the right of an individual or groups, if the rights are violated, people can directly approach the Supreme Court. No need to even go to the High Court. You can directly approach the Supreme Court. You can of course go to High Court. That's no one is stopping you. But the power of fundamental rights can be verified, can be ascertained from this right, that you can directly approach the Supreme Court, and the Supreme Court finds out that you are right or rights are violated, the Supreme Court can strike down the action taken against you. So let's say my right to equality is violated, I go to the Supreme Court. Now the Supreme Court has special powers, which is referred to as writs. Which is referred to as writs. What are writs? They are special orders issued by the courts. They are so, which means to ensure quick and effective justice. The courts, they issue writs. Writs are nothing but they are special legal orders that prevent or correct the violations. There are 5 types of writs that you need to remember. Which are the 5 types of writs? The first one is habeas corpus. Habeas corpus means to have the body of. So let's say, for example, the police has detained me, or let's say arrested me. So my lawyer approaches the judiciary and states that the police has arrested me illegally. And if the court finds out that the police has arrested me illegally, the court will order the police to release me. To release me. So if the arrest is illegal, then this habeas corpus writ is issued by the judiciary to make or to set a person free. This is the first type of writ. The second is mandamus. What is mandamus? It is issued when a government official, when an IS officer or IPS officer is failing to perform his duty. Let's say, for example, you go to the government official, let's say, to report a crime. Now the police officer says that I'll not report your crime. Then you can approach the judiciary stating that this officer is refusing to, refusing to note the crime. Then in this case the court will issue an order to the government official stating that why haven't you taken action, and will order the official to take action, which means to lodge a complaint. This is referred to as mandamus. The third is prohibition. The third writ is prohibition. What do you mean by prohibition? Which means prohibit. It is issued by a higher court to a lower court, which means Supreme Court to High Court or High Court to lower courts, district court. Now, if the lower court, if the higher court finds out that the lower court is exceeding the jurisdiction, which means every court has certain powers, certain area of influence, certain jurisdiction, they cannot go beyond that jurisdiction. For example, when you are a district collector, you are in charge of that district, you cannot give order in another district. So if the lower court is exceeding the jurisdiction, then the higher court will stop the lower court from exceeding the jurisdiction. We stop the lower court and tell, please do not exceed the jurisdiction, you are not authorized to take this decision. The next writ is quo warranto. Now, what do you understand by quo warranto? Which means it questions the legal authority of a person holding a public office. For example, let's say tomorrow I cannot go, let's say, to a collectorate office and sit on the chair of a district collector. I cannot go to the Rashtrapati Bhavan and sit on the president's chair. If I sit, the court will question me that under which, or do you have the authority to hold the public office? If the court finds out that the person is not legally entitled to the position, then they are removed from office. This is referred to as quo warranto. By what authority are you holding the public office? Then the last is the fifth writ, certiorari, which means it is again, it allows a higher court to transfer a case from a lower court. So here the Supreme Court has the power to transfer a case from the High Court to Supreme Court. The High Court has the power to transfer a case from the, let's say, lower court to High Court. This is referred to as certiorari. These are the 5 types of writs which the Supreme Court or High Court can issue when the rights of individuals are violated. When the rights of individuals are violated. And then which are the other mechanisms for the protection of rights? Which are the other mechanisms? For example, we have the National Commission, right? National Commission for minorities. We have National Commission for women. We have National Commission for scheduled castes. We have National Commission for scheduled tribes. We have National Human Rights Commission. These are the other mechanisms which are also interested with protecting the rights of people other than judiciary. The question is, why is this right so important that Dr. Ambedkar referred to as the heart and soul? Why? Because legal action can be taken against the government. If the government abuses power, takes away the right, legal action can be taken. This right is a key safeguard of democracy. It allows citizens to hold the government accountable. It allows the citizens to hold the government accountable and then seek justice, get justice, especially when the rights are violated. That's the reason this right is referred to as the heart and soul of the Indian Constitution. Understood? Now, students, it's time to understand the concept of directive principles of state policy, right? In the last class, we discussed or had a brief idea about what DPSP is all about, but here we'll understand in more detail what exactly is DPSP. Now, the framers of the Indian Constitution, that is the members of the Constituent Assembly, they knew that independent India would face many challenges, especially in ensuring equality and well-being, social welfare for all. They also wanted to guide the future governments while ensuring that the policies were not legally binding. Here, they wanted to give a direction to the future governments that these are the things that we are expected to follow in the future. And that's the reason they included directive principles of state policy in the constitution. Right? So, what are directive principles? See, these are the principles. There are some XYZ principles. We'll understand which principles. These are the principles that are directed to the state, that is, to the governments. Now, these principles are not legally enforceable, not legally enforceable, which means if these principles are violated, you cannot approach the judiciary. Like fundamental rights, you could approach the judiciary. Here, you cannot approach the judiciary, which means they are just morally binding on the government. They are morally binding on the government, which means the government has to ensure to include these principles in their governance, and the citizens can also hold the government accountable through these provisions. So, what exactly do the directive principles of state policy contain? Now, if you look at the DPSP, there are 3 key areas. One is one the goals for society, which means the goals are social and economic objectives which India should achieve. Socially, right, there should be no discrimination. Socially, all the groups should get same treatment. Healthcare, education. Economically, there should be employment opportunities for all the sections. Then additional rights for individuals. Second, additional rights for individuals. For example, again, the social and economic rights which are beyond the fundamental rights. right to education, which later on became fundamental right, right? Then equal pay for equal work, and then policy directions for the government. Third is policy directions. Policy directions for the government, which means guidelines for governance and decision making. And why? So as to ensure that there is social and economic justice. Now these principles reflect the vision of the members of Constituent Assembly. These principles will ensure that the society is fair and just. The society is equitable and like fair and just or equitable. What about the implementation of directive principles of state policy? Now, over the years, the government has taken many steps to implement these principles. Which are the initiatives? For example, let's take few examples. For example, abolition of zamindari system, abolition of the zamindari system. One, zamindari system was abolished. Why? To ensure land reforms, which means the government will take the excess land from the landholders and redistribute among the landless people so as to make our country food secure. Then nationalization of banks. Second is nationalization of banks to bring the banks under the control of the state. Why? So as to give credit money to the poor people. Then the laws, the factory laws made by the factory. Why? To regulate the working conditions, which means people are not exploited and there should be minimum wage given to each and every worker. Then promotion of cottage and small industries. Promotion of cottage and small industries. Why? Again to support the rural economies. Then reservation policies. Reservation policies given to the scheduled castes, scheduled tribes. Then Manarega. Mahatma Gandhi National Rural Employment Scheme. Why? To provide partial right to work. Then we have midday meal scheme. So these policies show how the governments have worked to implement the directive principles of state policy. And these principles ensure what? Social justice, economic equality, and most importantly, dignity, dignity for each and every citizen. This is directive principles of state policy. Now students will understand the concept of fundamental duties. Now you tell me, if the country has given you rights, doesn't the country expect you to, you know, follow certain duties towards the state, towards the country? Now this realization, our country realized that in response to the rights that people get, people are also expected to follow their duties. That's the reason in 1976, during emergency via the 42nd Constitutional Amendment Act, Fundamental Duty chapter was introduced in the Indian Constitution. Finally, people realize that yes, it is important that citizens should also show some maturity, responsibility. Now, these again, they are not legally enforceable. They are not legally, which means you cannot punish a person if they are not obeying the duties. They are not obeying the duties. So, as responsible citizens, we should abide by the constitution and uphold the values. We should defend the country, contribute to the national service. We should promote unity and harmony. We should protect the environment, natural resources, These are the duties. These are the duties that every citizen is expected to abide by, follow. Now, most importantly, the enjoyment of fundamental rights is not conditional. Fundamental rights is not conditional to fundamental duties, which means it's not the case that only when you obey the duties, follow the duties, you can enjoy fundamental rights. It's not conditional on following fundamental duties. Even if you don't perform your duties, you still have the rights. You still have the rights. But these fundamental duties, they serve as a moral reminder to the Indian citizen, moral reminder of our civic responsibilities. I hope you understood what is fundamental duties. Now, students, it is important to understand the relationship between the fundamental rights and the directive principles of state policy. What exactly is the relationship? Now, see the fundamental rights and DPSP, they play complementary roles. Fundamental rights, it protects individual freedoms. It provides or it protects the government from violating the rights of citizens. And DPSP, it promotes social and economic justice. It works for the welfare of people. So again, if you see the fundamental rights, they focus on personal liberty. DPSP, it aims to create an equitable society. However, the conflicts sometimes arise between the fundamental rights and DPSP. How? For example, the government's land reforms policies, right, to abolish the zamindari system were challenged. Why? Because they are violating right to property. We discussed, right, land reforms, which means the government will take away the extra land from the zamindars. Now, right to property was a fundamental right. Now, government actually wanted to ensure the welfare of people, so the government wanted to take the extra land from the zamindars. The zamindars protested. They said that this is violation of our right to property. So there's a clash. So welfare measures under DPSP were clashing with the fundamental rights, and this led to legal disputes. So government was taken to the court, and government argued. What the government argued? The government argued that fundamental rights should be restricted to implement DPSP, which means government should be allowed to violate fundamental rights to implement the DPSPs. Why? Because the DPSP, the purpose of DPSP is social and economic justice. The judiciary insisted that fundamental rights were supreme and could not be violated, even for welfare purposes. Which means here the judiciary, it actually supported the petitioners who challenged the decision of the government, and this dispute led to the famous Kesavananda Bharati judgment. It led to the This was a landmark decision given by the Supreme Court. The Supreme Court decided Parliament can amend any part of the Constitution. Now, initially, Supreme Court said you cannot violate the fundamental rights. Now, Supreme Court says that Parliament has the power to change any part of the Constitution, but cannot change the basic structure. What did the Supreme Court say? In the case of the Bharati judgment, Parliament can amend any part of the Indian Constitution but cannot amend basic structure. What is basic structure? A basic structure, which means there are certain principles which the Parliament cannot ever challenge or change. Cannot ever. Which means, for example, secularism. This cannot be challenged. This is referred to as basic structure doctrine. This doctrine states that there are certain principles which cannot ever be challenged. Now the government can amend the fundamental rights to implement the DPSPs, but still they cannot amend the basic structure doctrine. Which are the basic structure doctrine? For example, we have, let's say, federalism, parliamentary sovereignty, secularism. These are some of the basic structure doctrine. Right to equality, separation of power. These are the principles which cannot ever be amended. Now, what about right to property? Now, we know that right to property was initially a fundamental right, which means now whenever the government was trying to take away the land of people, people used to approach the judiciary. Now, for public welfare, the government had to take the land or have control over the land so as to ensure that people are benefiting. And then somewhere the judiciary realized, yes, public land is important for the government so that the government can use the land for public welfare. That's the reason right to property was deleted from the fundamental rights. Initially, there were 7 fundamental rights. This was the 7th fundamental right. This right was removed from the Indian constitution, that is from fundamental rights, which means right to property, which was a fundamental right, now became a legal right under Article 300A of the Constitution, which means now right to property will not enjoy the same right as it was enjoying under fundamental rights. I hope students you understood this concept, and this marks an end to the chapter number 5, that is constitutional design. I hope you understood each and every concept. Now, to understand if you understood each and every concept, here are a few MCQs that you can try to attempt. Question number 1. Which of the following statements regarding right to equality under the Indian Constitution is not correct? We have discussed what is right to equality. The state shall not discriminate against any citizen on the ground of religion, race. Yes, the first statement is correct. So I just want you to read by your own and then write the answer in your book and see which option is correct. The practice of untouchability is abolished and its enforcement is punishable. Equal pay for equal work is guaranteed as a fundamental right under Article 14. The state can make special. So, the statement which is incorrect is C, because equal pay for equal work is not part of fundamental right. We have not discussed this part. So, not discussed as part of Article 14. So, equal pay for equal work is not mentioned in Article 14. Next question. Which of the following writs is issued by the court when a lower court or tribunal has overstepped its jurisdiction? Now, we discuss all the types of writs for the enforcement of fundamental rights. Now, which of the following writs is issued? The answer is certiorari is the writ issued by the higher court when the lower court is exceeding its jurisdiction. Next question. Consider the following statements regarding the right to freedom under the Indian Constitution. The Constitution provides absolute freedom of speech and expression. Does it provide absolute? We have discussed so many times that no right is absolute. No right is absolute, which means again this statement becomes incorrect. The freedom to assemble can be exercised only in a peaceful manner and without arms. Yes. The government can impose reasonable restrictions on personal liberty in the interest of sovereignty And yes, this statement is correct. So first statement is incorrect. Option B is the correct answer for question number 3. Right? Next question. With reference to right against exploitation, consider the following statements. The Constitution prohibits human trafficking and forced labor under Article 23. Does the Constitution prohibit? Yes, the Constitution prohibits. Children below the age of 14 are prohibited from working in any occupation or industry under Article 24. Yes. Prohibition of children from working in hazardous factories. Bonded labor is explicitly mentioned in Article 24 as a form of prohibited exploitation. Bonded labor. It is not explicitly mentioned in the Indian Constitution. It is not explicitly mentioned in Article 24. So, this statement is incorrect, which means option A is the correct answer for question number 4. I hope students were in a position to address this question. These questions are not that difficult. I have explained each and every point while as discussing fundamental rights. I hope you are in a position to attempt these questions. If not, I request you to please go and rehear the chapters or rehear the concepts again. The last question. Which of the following best describes the significance of the right to constitutional remedies? Please attempt the question by your own. Very simple question. I am not going to answer this question. Do you want me to answer the question? Okay, so it allows president to amend the fundamental rights. It grants citizen. The option is correct answer is option B. Very simple question. You can approach the Supreme Court and High Courts directly if your fundamental rights are violated. And this brings us to the end of chapter number 5. I hope since you have understood each and every concept clearly. Right, on this note, let us call it a wrap. Thank you so much for watching.